Specifically, the case law says...
Whoa. How the heck do you jump to that conclusion? So if you show me a case, Mr. Martel, that says under those circumstances the court shouldn't hear it, then show me the case. Otherwise, you're wasting my time. You need to file a written motion. How long is that going to take you?
Judge,
how long is that going to take you?
Judge, certainly...
How long is that going to take you? If it's not going to be a lie, go for it.
Judge, respectfully...
No, you lied to me.
Darren Dwayne Wilson, sir, please stand and give your full and complete name for the record.
Darren Dwayne Wilson.
Thank you.
Judge, if I may, very briefly.
All right.
Thank you, Judge. And certainly, Judge, I got much respect for this honorable court, been before this court a number of times. Judge, but the court rule is clear, Judge, that a examination must be conducted by a neutral and detached magistrate, Judge. In this particular case, and just for a little bit of context, for Your Honor, this is a case where there's already a co-defendant, where an examination has been held, where the testimony has been taken, where the victim or complainant absolutely identifies a mixed race, ethnicity, light-skinned male, certainly not my client who's dark brown skin with barrel rolls. Judge, notwithstanding saying, Your Honor, the sole basis that the people intend to introduce quote-unquote identity is through the search warrants and the subsequent evidence that was purportedly obtained thereafter, Judge. I say that all to say that, Judge,
I don't know what case you're talking about. Who's the co-defendant?
You didn't preside over that. I could make the argument a lot more.
I did not preside over it?
No. So the argument that the counsel is attempting to...
Well, then I'll let him finish, because I don't know, it did not even begin to ring a bell with me.
It shouldn't.
but if I can just streamline it, Judge. In brief, Your Honor was presented ex parte with two search warrants in this particular case. Ultimately, these two search warrants, there was information heard, there was a search warrant, there was probable cause found, there was search warrant signed. Judge, we now come before you for a separate analysis of whether there's probable cause in this case, but Your Honor, pursuant to People Be Real, which is 391-124, Judge, it certainly cannot be neutral and detached when Your Honor respectfully has already found probable cause in this case, and specifically the case law says... Whoa.
How the heck do you jump to that conclusion?
Today, we're back in Judge Simpson's courtroom, and what starts as a routine legal argument quickly turns into a brutal credibility test. An attorney walks in confident that he has a strong case for getting the judge off the hearing, but the moment Judge Simpson starts asking simple questions about the case law and the actual record, everything begins to unravel. The attorney relies heavily on search warrants, prior proceedings, and a case he claims supports his argument. But Judge Simpson isn't willing to accept vague claims or legal conclusions without proof. He pushes back, asks exactly where the authority is, and eventually tells the attorney to show him the case, or stop wasting the court's time. And then comes the moment that changes the entire hearing. After taking a recess and checking the record, Judge Simpson returns with a serious accusation. The attorney allegedly misrepresented who handled a previous examination and may have selectively presented the case law. What follows is an uncomfortable courtroom confrontation over credibility, accuracy, and whether the request to remove the judge is actually an attempt at forum shopping. The judge doesn't immediately shut everything down. Instead, he gives the attorney a path forward, but makes it clear that the motion needs to be put in writing and supported properly. So, was this a legitimate legal argument that simply went badly, or did the attorney cross a line by misleading the court? Let's get into the hearing and see exactly how it unfolded.
And there's the judge's key point. He says he reviewed the search warrant documents, but he did not hear witnesses testify. That matters because the defense's entire recusal argument depends on the idea that the judge already evaluated testimony in a way that could affect his neutrality. So now the question is simple. Can the defense actually show a case that supports this argument?
The probable cause that's determined from a search warrant is based upon that evidence that is presented to me in the form of an affidavit on that search warrant. That's going to have no bearing whatsoever on what testimony I hear or don't hear in this case. So I don't even know how you get to that conclusion. But I'll let you continue because I think it's a... Go ahead.
Thank you, Judge. And Judge, just certainly to preserve the record, certainly I don't want to come back on a quash or an appeal or even a remand, Judge, but the case law is clear. It says that the defendant requests a magistrate other than the magistrate who has already heard ex parte witnesses, such as the request should not be or should be regarded as reasonable and reasonable efforts exerted towards compliance, Judge.
What ex parte witnesses did I hear from?
Judge, Your Honor signed both of the search warrants in this particular matter, certainly testified.
But that says I've heard from witnesses. I've not heard from any witnesses.
Judge, so if it's your
Does
position,
that case clearly apply to search warrants?
that it's not limited to search warrants. But if,
That isn't what I asked you, Mr. Martel.
yes, Judge.
Is that applicable? I could certainly see a circumstance where I would have heard, like what you started out with, which doesn't seem to be true, that I heard something and then there would be a request that I not hear it because I've heard the witnesses or testimony. And so in that circumstance, there would be a much different analysis. But now you're trying to cite a case, apply it to something that I don't think that applies to.
Judge, what I'm
Just by the very words that you said, and certainly you show me that it says that a judge that has, or a magistrate that has signed a search warrant should not then hear the preliminary examination where they've made a finding.
Judge, specifically, this relates to an arrest warrant, not a search warrant. However, if it's the position of the court that Your Honor has heard no testimony, sworn testimony or otherwise, then I guess our request would be moved. But
I have read, so that we're clear, because you're playing fast and loose with words. So that it's clear, I would have read the search warrant. I don't recall receiving any testimony at all regarding that search warrant, because I typically don't. I make a determination if there's probable cause contained within the four corners of that document, swear the individual in, sign off on the search warrant. It's really as simple as that. So if you show me a case, Mr. Martel, that says under those circumstances the court shouldn't hear it, then show me the case. Otherwise, you're wasting my time.
Judge, so acknowledged, I would say that Burrell is applicable, and I would also humbly submit, Judge, the position of the court that anything outside the four corners of the exam transcript has been analyzed or sworn to, then it would certainly fall.
Then you're going to need to file a motion so I can, if it doesn't bear out, I can find it frivolous and I'm going to adjourn this and then I can sanction. You need to file a written motion. How long is that going to take you?
Judge,
How long is that going to take you?
Judge, certainly.
How long is that going to take you? If you cannot answer that question, then I will take a recess. I will give you time to think about that. And then I will come back and I need your time frame for how soon you can file the motion. In fact, why don't we just do that?
We're prepared to proceed.
Why don't we just do that? You can take him back. Court's going to stand in recess.
And good afternoon once again, Your Honor. Good afternoon to your fine staff. May it please the most honorable court. Edward Martel, P85051, on behalf of Darren Dwayne. Please state your name once again for the record.
Have a seat. So, Mr. Martel, I'm a bit concerned. I just take what people give me. But I'm just going to say this. You lied to me at the very beginning of your argument. I went back, had my staff go back. You said that I held a preliminary examination on the co-defendant. I couldn't recall it, but it's not true. That was an absolute falsehood and misrepresentation to this court. Ms. Hughes then points that out, but I'm still not sure. On the break, I go back, have my staff.
Judge Simpson isn't saying your argument is impossible. He's saying, show me the authority. That's a huge difference. In court, confidence and repetition don't replace legal support. If you're asking a judge to step away from a case, you need a specific rule or case that actually fits these facts.
Look it up, which was some doing, but if the case that you're referring to as a co-defendant is Christopher Harrison, I didn't handle that exam. Judge Barr handled that exam. So your initial argument regarding refusal started with and I hate using the word, but it's true, it started with a lie. Then, Mr. Martell, you continued with your lie regarding the import of the case of People versus Burrell. You cite one portion of it about a magistrate who takes testimony and does that, and that's why I went through exactly what this court does regarding search warrants. And then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph to mislead this court. And I'll tell you what it says. It says, whereas here, an affidavit presented to a magistrate was in conclusory form, which I'm sure those search warrants were, and did not state any of the underlying or operative fact, and no witnesses were examined, which they weren't, we can perceive no prejudice to the accused in having the magistrate who issued the arrest warrant, which is different, preside at a preliminary.
Now the entire tone changes. After checking the record during the recess, the judge comes back saying the attorney's description of the earlier proceeding was not accurate. And that's a devastating problem in any courtroom argument, because once credibility becomes the issue, even a potentially legitimate legal argument can become much harder to sell.
Examination.
If I may,
If it's not going to be a lie, go for it.
Judge, respectfully,
No, you lied to me.
okay, if I may, Judge, very briefly, I think the record will reflect it. When I cited or spoke about a preliminary examination, I didn't speak directly as to this court having held it, but it having been previously held. I was not present at that particular examination. However, Judge, certainly I would make no false representations as to who held it or who didn't hold it. I think I just provided that for context.
You want me to play it back?
Judge, I certainly do not. But
You want me to play it back?
Judge, I certainly, if Your Honor, some other time wants to, that's fine.
No, if you're going to sit up here and tell me you didn't lie to me, you want me to play it back?
Judge, then I stand corrected, Judge, but I certainly intend to make no misrepresentations of the context. The main argument is what it is. And certainly, Your Honor is not barred from presiding over this exam. But again, and I've spoken with my client in the basis of just preserving the record and putting forth this argument, certainly mean no disrespect, harassment, or delay to the people. Judge, we're prepared to proceed. If Your Honor intends to deny, that's fine. Again, we're prepared.
I don't know what your motion is, because everything that is presented to me is not it. Anything else, Mr.
Judge, just very
Martell?
briefly, and I certainly respect this.
Because I'm going to tell you that, quite frankly, Mr. Martell, one may have to convince me why you have not, only in terms of your misleading of this court, attempted to try to have this judge recused for the purpose of forum shopping.
Absolutely.
Because, I think so. Because originally I had to step into this case, and I can tell you, you probably weren't necessarily real excited about it. But that's the way that the system works here. And so I think you're continuing on with that. And because there's no other reason, I think, to try to bring this frivolous argument.
Judge, respectfully, I certainly enjoy practicing before Your Honor, and I certainly had no intent to mislead this court, or in fact, I'm pull the exam or the transcript thereafter. As far as I don't believe any misrepresentations were made to this honorable court, Judge. I stand firm on my word. At the end of the day, I think there's a basis for our argument to put forth. If it's the position of the court that it's not, certainly, Your Honor, we will move forward with your denial, and we're prepared for.
I have not ruled. You will hear my ruling loud and clear.
Yes,
But do not presume that I'm going to deny it. Before I stepped off the bench, I asked, and I think properly so, your motion should be in writing. How long will that take you to do? If you
And Judge Simpson goes even deeper into the case law. His criticism is that the defense highlighted language about a magistrate hearing testimony, while the surrounding language dealt with a situation where no witnesses were actually examined. In other words, the judge believes the missing context changes the meaning of the argument completely.
won't answer me, then I will set the time frame.
2 weeks, please, and thank you, Judge.
Defendant's motion to recuse would need to be filed by December 10th. Prosecutor will respond by December 20th. I will hear the motion on December 26th. This exam is moved to December 26th, 2024 at 12 noon.
Thank you.
Despite all of that, the judge does not simply shut the door. He gives the defense a deadline to put the recusal argument into a written motion with a response from the prosecutor and a hearing date set. So the attorney gets another opportunity, but now the argument has to survive on paper, backed by the actual record and the actual law. Was that fair, or should the courtroom confrontation have ended the matter right there?